Welcome to another week of business law. This week, I'm testing out a new microphone here, so please let me know if there's any issues with the sound. I do believe that the prior sound issues should have been resolved with this new microphone that I have now. This week, we're going to talk about criminal law, probably one of the more interesting aspects of the law. Even though I don't practice in that area, I'm pretty familiar with criminal law in general. Most people are probably familiar with criminal law as well, only because that's the area of the law that's most depicted in shows and movies and so forth. But I think you'd be surprised to learn the extent to which criminal law is philosophy. It's more philosophical than anything else. If you were taking this class in law school, you would be exploring the philosophical aspects of punishment and so forth. So it's actually a really interesting topic. For purposes of this chapter, we're going to talk a little bit about the nature of crimes, white collar crime, which has taken on added prevalence the last 10 years, I want to say. Crimes against businesses, so not only can businesses commit crimes, but also many times people commit crimes against the business entity itself. We'll talk about some defenses to crimes and then criminal procedure. Please bear in mind that the nature of crimes in criminal procedure are going to vary from state to state. They're going to be different. Most of it should be similar, but there will be minor differences from state to state and so forth. So that will also be the case as between federal and state crimes. But again, we'll talk a little bit more about that as well as we proceed. So let's talk a little bit more about the nature of crimes. Well, criminal law is designed to prevent harm to society. I think when we were last together, I spoke a little bit about that and the fact that really when we live in society, we enter into a social contract where we obtain certain rights, but in return, we have certain duties and obligations. So what criminal law is designed to do is designed to prevent harm to society as a whole. And what criminal law does, it defines conduct that we consider criminal. And it establishes punishment for such conduct. Obviously, this is going to be a reflection of the society's morals, which we talked about last class. And so we will certainly have variations across time, across countries, and across different cultures. Because again, whatever is acceptable to society will be the basis, or the other way around, when we're talking about criminal law, is whatever is not acceptable to society is going to be then the basis for criminal law. So let's talk a little bit more about the crimes itself, or what do we mean when we say crime. So what is a crime then? It's any act or omission that's forbidden by public law. Remember, public law is that law that deals with the interaction between the government and individuals. So criminal law would be public law. So any act or omission that's forbidden by public law or criminal law, in other words, would be a crime. Now, there are essential elements to a crime. So the prosecutor, in order to convict a person of a crime, needs to prove at a minimum these two elements. There's actually more than that. But the first essential element of a crime is what we call the actus reus. That's the actual wrongful or overt act. And you also need the requisite mens rea, which means the criminal intent or mental fault. So in other words, not only do you have to commit the act, but you also have to have the intent or the desire would probably be a better word, the desire to commit the act, right? So there are certain crimes that we do punish that are accidental in nature, but most require the intent. And it really makes sense if you think about it, right? Because if you didn't intend to do something wrong, Do we really want to punish you? And the answer to that is yes. If you committed the wrongful act, you're still going to be punished, but you're going to be punished to a lesser or lower extent if you didn't intend to commit the act, as opposed to whether you did or not. We'll talk a little bit more about the actus reus and the mens rea. The mens rea requirement is what's usually attacked the most by defense attorneys. Because the act is very simple to prove or disprove. You either did it or you didn't. You either killed somebody or you didn't. You either stole something or you didn't. That's the act. The mens rea, again, is a little bit harder because now we're starting to look inside people's minds, right? Did they intend to kill somebody? Was it premeditated? Was it thought out? Was it planned? Or was it accidental? So those are the types of things that we're going to look at. And that's why defense attorneys really attack the mens rea, because that's really the only essential element that can be attacked, because it's very difficult to know what a person was thinking at a particular time. So we'll talk a little bit more about that as we get there. There's also different degrees of mental fault when we're talking about fault in general, which again, it makes sense if you think about it, right? The more you wanted to do it, the more we're going to punish you, right? So if you know that an act is wrong and you still do it, then you're more guilty than somebody that breaks the law but didn't intend to do it. So let me think of a couple examples of that I could give you. There are statutes that have modified this a little bit, so it's not the best example, but an example of this would be murder, right? Let's look at murder. Let's say you kill somebody and you intended to do it. You really dislike the person. You've been thinking about this for months. You've been planning it out. Or you actually went out and hired somebody to kill your spouse, for example. That actually happens a lot more than people think. Then obviously at that point, we really want to punish that person, right? That person was thinking it through. That mens rea requirement is there. There's that intent. Whereas another example would be, let's say that you go out at night, you drink, you shouldn't drive, but you do, and then you get into an accident and you kill somebody. Well, it's still a crime. We want to punish that. We definitely don't want people to drink and drive. So we want to deter that type of behavior. And obviously you killed somebody. So you do deserve some type of punishment. Society demands it, right? It's a crime against society. So society demands retribution. So at that point, but you didn't intend to kill somebody, right? I mean, you should have known that's a possibility that could happen. But you didn't plan it out. You didn't want it to happen. So we're going to punish that person less than we would somebody that sits down and plans it out for months. And that's what we mean by different degrees of mental fault in general. The book in this slide talks about subjective, objective types of fault, and also liability without fault. So I'm going to talk a little bit about that. When we talk about subjective fault, the type of fault that's required is purposeful, knowing, reckless. You knew, you planned it. That's what we mean by subjective fault. So examples of that would be larceny, embezzlement. So murder would be another example of subjective fault. Objective fault was like my drunk driving example that I gave. That's when you're negligent or careless. Could be careless driving. In some states, it's issuing bad checks. Although I don't think issuing bad checks is necessarily negligent. I think it depends on the situation. A lot of that may be subjective. And then we have a few rare circumstances in the law where there is liability without fault. So it doesn't matter whether you were negligent or careless, or you intended it or you didn't intend it. Doesn't matter even if you took every precaution possible. It doesn't matter. If you do it, if the act happens, you're liable, guilty, no matter what. So sale of an alcohol to a minor, for example, would be an example of that. sale of adulterated food, um, statutory rape. Those would be the types of cases where there would be liability without fault necessarily. Let's talk about the different classifications of crimes, and also something called vicarious liability, which is actually a very important concept. When we're talking about crimes, we normally classify them into two different categories. We have felonies and misdemeanors. A felony is a serious crime. A misdemeanor is a less serious crime. A better definition of that would be a felony is any crime that's punishable by a year or more of jail. So if the crime is punished by a year or more, that's considered a felony. And a misdemeanor would be anything less than that. So if the punishment is either a fine or anything less than 6 months in jail, then that would be considered a misdemeanor. Vicarious liability. That's the liability imposed for acts of employees if the employer directed, participated in, or approved the acts. Normally, employers are not criminally liable for the acts of their employees, and that's pretty obvious, right? I mean, we have that mens rea requirement. There needs to be intent. So if you didn't know that your employee was going to commit a crime, as an employer, you can't be liable. But there are a few exceptions. And again, that's what we call this vicarious liability here. So if the employer directed, right? So in other words, you didn't steal, but you sent your employee to steal, then that would be vicarious liability. You would be liable. Or if you participated in, that one's pretty obvious. Or if you approved the act. So in other words, you knew what was going to happen and you approved it. You got to be careful with that one as well, right? Because approving it may mean silence when there's a duty to speak. So if you overhear your employee, for example, the criminal activity, right, or the intent of your employee to commit a criminal act, and you do nothing, then you may be vicariously liable, even though you didn't participate in, you didn't direct it, or you didn't approve it. But the law will actually say that your silence when you had a duty to speak, right, and stop that act or report it to the police, your silence in essence is approval. So we call those acts of omission, right? So you got to be careful with those as well. If you're an employer, if you have a duty to act, then you must act. What about the liability of a corporation? Under certain circumstances, a corporation may be convicted of crimes and punished by fines. If the corporation participates in criminal activity, and obviously we know that the entity itself is considered a person under the law. We also know that the entity cannot act alone, right? It needs to act through its board of directors, or actually better said, through its officers, right? The president, the vice president, those are the ones that direct the day-to-day operations of a corporation. So, under certain circumstances, then, if a corporation participates in a crime, for example, the stealing of trade secrets, for example, right? You're Pepsi and you go after Coke and you actually steal the secret formula. Well, that would be the type of crime that you would be liable for as a corporation. Again, remember, this is irrespective of any civil liability you would have, right? Coke would probably sue you for their damages, but aside from that, there may be also criminal penalties related to that. And at that point, obviously, we can't put a corporation in jail. Probably the officers would get charged and they would serve jail time, but also the corporation may be fined. So the equivalent of putting a corporation in jail would be to fine the company. Let's talk a little bit about now, let's move into white collar crime. And as I mentioned in class, white collar crime have been traditionally defined as those crimes that are victimless, although that's not necessarily true. I guess probably a better definition is that they're not violent crimes. So the book defines it as nonviolent crime involving deceit, corruption, or breach of trust. Um, I would say we could probably expand those categories further and include some other areas, but that's a pretty good broad definition of what white collar crime is. Within white collar crime, we also have computer crime. It's the use of a computer to commit a crime, and we're starting to see more and more of that. There's a lot of internet fraud going on, phishing, for example, identity theft. Those are the types of crimes that involve computers. And so computer crime can be very, very broad. The thing with computer crimes, it can be white collar crime that's really non-violent, but there are some type of computer crimes that in my opinion, cross that line and actually do get almost into that um, equivalent of some of the other violent crimes. An example that would be child pornography. There's a lot of people, a lot of kids that are exploited, that are hurt as a result of that. And so that would be a computer crime that, in my opinion, uh, would not be considered white collar, but would cross that line into some of the more traditional, violent, what we would consider violent type of crimes. There's a very important federal statute called RICO. It's the Racketeer Influenced and Corrupt Organizations Act. We also have a similar RICO statute in Florida. I believe it's chapter 867 of the Florida statutes. But in essence, it's a federal law intended to stop organized crime from infiltrating legitimate businesses. What was happening is a lot of these organized crime families knew that when you're generating millions and millions of dollars in illegal profits, whether it be through prostitution, gambling, drugs, arms, whatever the case may be, the IRS started coming down. A lot of times when the federal government could not crack down on a lot of these crimes, because a lot of times it was very difficult to find the proof or to catch them, they were actually catching a lot of these organized criminal organizations on tax evasion and other tax crimes. And so what happened is a lot of these organizations started using legitimate businesses to run or launder money, run their illegal profits and try to somehow make them legitimate by running them through legitimate businesses. So the federal government came up with this act called the RICO Act to try and stop that. And it's very, very broad. So as I mentioned, it's very, very broad, and Florida has an equivalent. So that's all I'll say about it, because it's actually pretty complicated statute overall. Let's talk a little bit about crimes against businesses. We don't hear a lot about that a lot of times, or we don't associate, I guess I shouldn't say that. We do hear it, but we don't associate it a lot of times. Probably the two most common are larceny and embezzlement. Larceny is, the law defines it as a trespassory taking and carrying away of personal property of another with the intent to deprive the victim permanently of the property. So in other words, stealing, right? If you take somebody's property with the intent, see, look at the definition there. I think that's actually pretty important to look at, with the intent, right? So for example, ladies, if you go to a party and you leave your purses on a bed, for example, and when you leave, you take somebody else's purse that looks just like yours. Is that larceny? I mean, you certainly took and carried away someone's personal property, right? But the problem with that is you didn't have the intent to deprive the person permanently of the property. You thought it was your purse. So really that would not be larceny. So again, that's where the intent requirement really comes in. So in other words, you knew it wasn't your purse. You intended to take the purse that was not yours, and you intended to permanently deprive the person of that. You never intended to return it. So that's larceny. Larceny, very, very common crime against business in particular. Um, we see this a lot with shoplifting, for example. That would be a very good example of larceny from a business perspective. So again, in my opinion, larceny is probably the most common crime against business, especially retailers, which is simply shoplifting. Embezzlement is the taking of another's property by a person who was in lawful possession of the property. We see embezzlement a lot with insiders, accountants in particular, or bookkeepers. So what happens is obviously accountants and bookkeepers would have access to checks that come in. A lot of times they'll modify the checks or cash them simply and keep the cash and then cook the books, right? Put an entry that makes it appear that the cash was received when in fact, well, I shouldn't say that. It was received, but it just did not go into the business's account. The person kept it. So again, if you look at the news, there's a lot of embezzlement in general. And again, I would say those are mainly insiders. So to prevent embezzlement as a company, you want to have a checks and balance system, right? So anytime a check is written, for example, you would have two signatures. That would be one way, right? You don't give the accountant full authority to just sign checks. It would have to be countersigned by the president or an officer or somebody else. So it's important to have a check and balance system. So that's embezzlement, another fairly common crime against business, not as common as larceny, but I would say from a loss perspective, embezzlement is more harmful because usually by the time the company is able to figure out that there's an issue, and a lot of times this comes as a result of an audit, then it's usually, a couple $100,000, sometimes millions have been embezzled by the time the company actually finds out about it. False pretenses and robbery. False pretenses is obtaining title to property of another by means of representation one knows to be materially false. It's made with the intent to defraud. So again, an example of this would be a fraudulent check. So let's say you don't have any funds in your account, and yet you write a check knowing that you don't have funds in your account, and you get whatever merchandise, right? You're allegedly buying, but you never intended to buy it. Your intent all along has been to defraud. So that's false pretenses. Not as common as some of the other ones, but it's out there. It happens. Now, with the advent of technology that we have nowadays, very few people pay with checks anymore. In fact, a lot of businesses don't accept checks, and that's one of the reasons why. Now, robbery, larceny, theft, robbery, they're all the same thing, but with different elements. They're all stealing, but for example, robbery would be committing larceny with the use or threat of force. So in other words, let's go back to my shoplifting example. If you are at Walmart and you take a dress and you put it in your backpack, that's larceny, right? Now, if you're at Walmart, you take the dress, you put it in your backpack, one of the employees confronts you and you pull out a gun or a knife or a stick, or you threaten the person with force, now that's robbery. And it's significant. And the reason why it's significant is because we punish robbery to a greater extent than we do larceny. So if you're charged with robbery, you're going to serve more time in jail than if you're charged with larceny. And really the only difference between one and the other is the use or threat of force. Burglary. So again, right, here's another example. Larceny, robbery, and burglary, right? Very, very similar. They're all stealing. Again, just different elements. Burglary has a little bit interesting definition. Under most modern statutes, it's the entry into a building with the intent to commit a felony. In fact, some states even say at night. So if you, instead of it being Walmart, right? Let's say that you have a business that's only open from 9 to 5, and somebody breaks into your building to steal your inventory. Well, that would be burglary. And again, we do punish burglary to a certain extent, about the same as robbery, I would say. It depends on the state. Extortion. It's making threats to obtain money or property. Again, we don't see a lot with extortion, but for example, right, it could be that, extortion can take a lot of different forms. Probably one of the most popular from the movies or TV shows is that a person is having an affair, and I follow you and I take pictures of you with your lover. And then I threaten you that if you don't pay me $100,000, I'm going to publish the picture, or I'm going to send the picture to your spouse. Those are the types of things that would be considered extortion. And obviously we punish that as well. As it pertains to a business, a type of extortion would be, an example would be, let's say that you're a restaurant and I'm an employee, and I know that you're committing certain health code violations, and I document those, whether it's, take a picture or whatever. And it's the same thing, right? I go to the owner and I say, hey, if you don't pay me $10,000, I'm going to publish the picture with the rat in the kitchen, that kind of thing. So that would be extortion against the business. And again, it's not too common, but we do see it every once in a while. Bribery, forgery, and bad checks. I talked a little bit about bad checks before, but bribery, again, we probably don't see too much of that at our level. You usually see more of that in international business, that briberies are a lot more common. So bribery is offering money or property to a public official to influence the official's decision. It's interesting, in some international transactions, in some countries, bribery is actually expected. And you can't do business. In fact, some companies that do business in those countries where bribery is expected actually have a line item under budgets for bribing public officials. But for the most part, most countries do not allow it. And in particular, the US certainly does not. And there's actually a statute related to that. Because the problem with bribery in an international context is that it could create a very unfair advantage between competitors, right? Again, let me go back to my Coke and Pepsi example. Let's say that Coke bribes the public officials so that their inventory doesn't have to go through the normal customs process. So instead of inventory taking 4 days to clear customs, it immediately comes into the country. So now you've got a 3 or 4 day advantage over your competitor. So again, those are the types of things why we don't want bribery in general, is because, again, we want competitors to be able to compete on a level playing field. And besides, just bribery in general, going back to our ethics chapter, it's just unethical, right? It's just immoral to bribe to gain some type of advantage. But again, as I mentioned, in some countries it is expected. So there's not too much that can be done about that sometimes. Give you guys an example about bribery, real life example about bribery and how it's accepted and expected in some countries. In the early 1990s, I worked as an archaeological tour operator in the north of Chile. I ran archaeological tours throughout the north of Chile, into Peru, and also into Bolivia. I had a group of about 20 people that I was taking to Cusco and Machu Picchu in the south of Peru. And as part of that group, I had two older ladies that they were sisters, and they were, I want to say, 81 and 83, somewhere in that range, but they were fairly old. And we were in a particular city, and I told them, I gave them some free time to go eat at whatever restaurant they wanted to, and I told them, I said, look, from this street north, you could go wherever you want. From this street south, don't go. So what did they do? They went exactly where I told them not to go. So somebody slashed their bags and stole their passports. And they were Chilean. So I went to Peru's very interesting. They actually have tourist police. So I went to the tourist police. I reported the passport stolen. I got an official incident report. And so, there was not much I could do because they didn't have a passport. So I needed this document to get them back across the border into Chile. We had actually started the tour from Chile, and we were returning to Chile. Well, it so happens that at the border, we get to the border between Peru and Chile, and we're crossing back into Chile, and it was a Friday night, or Friday evening. It wasn't night yet, but it was in the evening. And we get to the border, and they ask these older ladies for their passports. And, obviously, I went up there and I said, look, they don't have their passports. Their passports were stolen. Here's the document that I received from the tourist police saying that the passports had been stolen. And usually with that document, that's enough. I don't need anything else. But they made a big deal about it, and they're saying, no, you need a passport. We can't let you across without a passport. I'm like, that's crazy. I've done this a million times. You don't need the passport as long as I have this document. And they stood their ground. They said, nope, you have to go back to the embassy and get a passport. I'm like, well, how am I going to do that? It's Friday night. These ladies are in their 80s. I would have to wait until Monday. I can't leave them behind. So, what do I do, right? And so they're like, well, that's your problem. I said, all right, let me talk to your supervisor. So then they made me wait probably for about an hour. And finally, they took me through this labyrinth inside their offices at the border and to this back room where they have this guy just sitting there at a desk. So I talked to him and kind of told him about, the problems and the issues that I was having. And he's like, well, there's not much that I can do. So I knew I had spent enough time in Peru and Bolivia that I knew that really the guy was expecting some type of bribe. So at that point, really what I said was, well, can I pay a fine in order to get these two ladies across? And so he thought about it for a few minutes, and he was like, well, maybe, but you made such a big deal at the border that, that fine's going to be pretty big because I'm going to have to share it with other people. So in other words, he's telling me he's expecting a bribe. So I was like, okay, how much? And so again, he thinks about it for 5 or 10 minutes, and then finally says, $100 per grandma. And I said, all right, done. So I paid him the $100 and I got him across the border. So again, that was something that was expected. I had a similar situation in the high Andes in Bolivia, in a very remote area, where the Bolivian military stopped. I was with a small van with about 6 people, and they stopped me and kind of something very similar happened where I had to actually pay a quote-unquote fine in order to be able to proceed. So again, in countries like Peru, Bolivia, In some other countries around the world, that's expected. Again, I lived in Chile at the time. If you did that in Chile, you'd go to jail. Chile, you can't bribe Chilean police or officers. And I shouldn't say that. I mean, certain people you could always bribe, but it's not expected. And actually, they take it as an offense. So it depends where you're at, right? So you have to know the country that you're in, and you have to know whether it's expected or whether it's a crime, right? But again, bribery in general is considered a crime here in the United States. Forgery, intentional falsification of a document to defraud. Well, that one's pretty obvious. It doesn't need any explanation. The biggest forgeries that we see are related to checks. So in other words, somebody is forging somebody's signature in order to cash a check. It happens a lot in business, actually. So again, you got to be very careful who's got control of the checks in the business. And it's not so much the checks, but it's more signing authority, right? Who's got the authority to sign the checks? So again, I think that the way to resolve that issue is you require a counter signature or two signatures on a check. So that's how you try and prevent a lot of this forgery. Bad checks, knowingly issuing a check without funds sufficient to cover the check. So again, I already talked about that under false pretense. That's really, it's the same thing. We do see that a lot in businesses as well, where people just give businesses bad checks, right? So if you're a business and you do take checks, again, not too many businesses still do, you do have to be careful with that. So let's talk about some of the defenses. We talked about, and again, remember, we're touching upon these crimes very, very lightly, right? We're not going into a lot of detail. There's a lot more crimes than this. There's a lot more, just a lot more in general. So really, we're only touching on this very lightly, in particular, those that are related to business. But if you've been convicted of a crime, well, I shouldn't say that, not convicted. If you've been charged with a crime, there are defenses that you can raise. Some of the most common defenses we're going to talk about here. One of those would be defense of person or property. So individuals may use reasonable force to protect themselves, other individuals, and their property. Key word there, reasonable force. So this is necessarily going to be done on a case-by-case basis, and the courts are going to look at if you're using self-defense, and really that's what this is, right? It's a self-defense type of defense. They're going to look at the circumstances. Here in Florida, we have a statute actually called Stand Your Ground. So that one is a little bit different than in a lot of states that don't have that. It's actually additional protection to protect yourself, in other words. And it's somewhat controversial, right? There was the Trayvon Martin case that was very, very popular, or got a lot of media attention here in Florida, and that was related to Stand Your Ground. Those of you that aren't familiar with Stand Your Ground in Florida, I would urge you to read a little bit about it, since it is a very, very interesting statute that deals with self-defense. In many states and in many circumstances, in order to be able to use self-defense as a defense, really you have to have no other available options. So in other words, if you can run, let's say somebody's threatening you, if you can run and get away from that situation, then the law says you have to do that before you can use force. Stand your ground says the opposite. Just like the name says, stand your ground. You can actually stand your ground. You don't have to run away. You can protect yourself as long as you have that reasonable expectation of or threat of force. So you could always use force to defend yourself and your property, but the force has to be equal to that being used against you. So for example, if somebody comes into my house, and actually that's not a good example, right? Because we do, in particular in Florida, we protect our property and our houses in particular a lot more than we would other areas. So if somebody breaks into your house, for example, and you felt threatened, either you or another family member felt threatened, you could actually kill that person and you'd be justified in doing it, even if the person was unarmed. Um, but in most situations, the force has to be, the defense has to be equal to the force. So if somebody has a gun, then you can use a gun. If somebody has a knife, you can use a knife, right? But if somebody has a knife, you can't use a gun. That's what we mean by reasonable force. We're also going to hold a higher standard as between people as opposed to property. So for example, if I'm protecting my family and I believe that my family is in danger of being seriously injured or killed, then I can use deadly force to protect them. I cannot use deadly force to protect property. Which, if you really think about it, it makes sense, right? Property is just property, right? If somebody's stealing my car and they're not armed and they're not threatened, I can't shoot them. Again, that's just common sense, really, more than anything else. But that's really the way it really works. Duress, it's coercion by threat of serious bodily harm, a defense to criminal conduct other than murder. And even then, I would say maybe you might be able to use duress even in a murder defense, even though that would be a tough one. So for example, duress would be, let's say you have a young child and I take your child and I put a gun to your child's head and I say, go steal the bank, right? Go steal money from the bank or I'll shoot your kids. I'll kill your kid. That's duress. So you go and you rob the bank, right? Did you do it? Yeah, you did it, but you did it under duress. It's a defense. You never had that person not put a gun to your kid's head. You never would have done it. So in other words, you don't have that mens rea, right? Remember, we're going back to those essential elements, right? Actus reus. Did you commit the act? Yeah, you did. You robbed the bank. Did you have the mens rea? No, you didn't. There was no intent. You did it under duress. You did it because you were forced to. And not only were you forced to, you did not have a choice. So that's what we mean by duress. It really has to be that extreme. Mistake of fact. Honest and reasonable belief that conduct is not criminal. Let me give you an example. I already actually gave you a good example of mistake of fact, right? It's when you go to that party and you take the wrong purse back with you. That's an honest and reasonable belief that, right? You thought it was your purse. You weren't intending to take anybody else's purse. That's a mistake of fact. Another example of that, let's say somebody gets so drunk that they live in a duplex and they open the door to the wrong house, right? So instead of going into their house, they go into their neighbor's house. That's a mistake of fact, right? They didn't intend to do it. They thought it was their house. So that would be where mistakes of facts come in. Remember, mistakes of law are not a defense to a crime. Remember, everybody's heard, right, that maxim or that quote that's mentioned a lot where it says, ignorance of the law is no defense. And that's what we mean by mistake of law. Just because you thought you weren't breaking the law, or you thought that the law didn't apply to you, or you didn't know the law, is not a defense. But mistake of fact is. Entrapment. It's inducement by a law enforcement official to commit a crime. Entrapment is used a lot in drug crimes as a defense. So if the police actually force or induce, right, don't give the person an option. In essence, if you force somebody to commit a crime, really they didn't intend to, but you kind of put them in that situation where they did, it can be entrapment. That one's a little bit tricky because entrapment is very fact intensive. So it's going to depend a lot on the facts, whether there was entrapment or not. And one of the key factors here to prove is, did you intend to do it or not? So in other words, if I do a drug sting operation, were you going to buy the drugs anyway, right? Let me rephrase that a little bit. what the judges or what the courts are going to look at is, did you have the intent to buy the drugs irrespective of the raid, right? So whether the cops had the raid there or not, you intended to commit that crime anyway, right? So again, we want to punish intent. So if you had no intention of doing it, but I entrapped you into doing it, right? Kind of pushed you into it, then really you don't have that mens rea element. You didn't intend to do it. That's why when you see a lot of these, I think 2020 or one of those shows used to do a lot of those To Catch a Predator type of things, right? Where you have all these adults that think they're gonna meet up with kids. What they do a lot of times, that's why a lot of times they'll tell them, right? So for example, when they're talking to the police officer on the phone, right, that the person believes is a kid, a lot of times they'll tell them, make sure you bring a blue teddy bear, or bring me some red flowers, or whatever the case will be. They'll tell them to bring something specific. And when they show up with that, that is the reason why the police is doing that, is so that they cannot use entrapment as a defense. By bringing those items, it means that they had that intent already to commit that crime. So that's the reason why they do that. So let's talk a little bit about criminal procedure. Criminal procedure is very, very complicated, and it varies from state to state. So each one of the states and the federal government has procedures for initiating and coordinating criminal prosecutions. So there's a specific step-by-step process that needs to be followed. In addition, the first 10 amendments to the U.S. Constitution, that obviously we call the Bill of Rights, guarantee many defenses and rights of an accused, right? So for example, your right to a speedy trial, your Fifth Amendment right to be silent. Those are probably the two most common. Well, here's a slide actually goes through them, the fourth, fifth, sixth, and eighth. So the fourth is freedom from unreasonable search and seizure. So again, if the police, if they're going to search your belongings, whether it's your car, your house, then they need a warrant. And in order to obtain a warrant, they need to show probable cause. So the Fourth Amendment really protects you from these unreasonable search and seizures. Most of the case law, most of the law that's been created by the courts in the Fourth Amendment context relates to drug cases. Fifth Amendment grants you due process. Due process, from a constitutional perspective, is simply notice and an opportunity to be heard. So in other words, notice of the crime that you are being charged with and an opportunity to be heard, a trial. The right to indictment by grand jury for capital crimes. So again, by capital crimes, we mean anything that deals with that the penalty could be the death penalty, right? So we want a grand jury to indict. Freedom from double jeopardy. In other words, you could only be tried once for a crime. That's why a lot of times the police will wait until they have sufficient evidence in order to bring the case. A lot of times the investigation may take a year, 2 years, 5 years sometimes, because they only get one shot at it. Once you try the case, if the person's found not guilty, that's it, you're done. Or the government is done, right? Freedom from self-incrimination, and that's where the right to remain silent comes from, right? The freedom from self-incrimination. You could just say, I take the fifth. Sixth Amendment, it's the right to a speedy public trial by jury. So you always have a right to a jury trial in a criminal case. In a civil case, you have to ask for it. In a criminal case, you always get it. You have the right to be informed of the accusations against you, right? So you have to be told what the charges are. You have the right to confront your witnesses. So in other words, you have a right to question the witnesses against you. You also have the right to present your own witnesses, and you have a right to competent counsel as well. The Eighth Amendment is actually very, very interesting. There's been a lot of litigation the last 5 years, maybe the last 10 years, under the Eighth Amendment. And the Eighth Amendment protects you, the individual. It provides freedom from excessive bail. So for example, right, if you steal, I'm going to give a very extreme example, right? Let's say you steal a candy bar. Well, let's say you steal $500 from a cash register. Well, the judge can't throw you in jail, right, and then require a $10 million bond. That would be an example of excessive bail. And the Eighth Amendment also grants you the protection from, or the freedom from, cruel and unusual punishment. That's where a lot of the litigation has been under the Eighth Amendment over the last 10 years. And that's because the death penalty has been challenged as cruel and unusual punishment under the Eighth Amendment. So again, I'll let you guys read a little bit about that. Very, very interesting, all of the discussions and the different cases that have been decided under the Eighth Amendment as it pertains to the death penalty and cruel and unusual punishment. So what are the steps then in a criminal prosecution? And they vary from state to state somewhat, but overall they're fairly similar. They generally include arrest. So first, right, you get arrested, then you get booked, then you are presented with formal notice of the charges against you. A lot of times that's done at a preliminary hearing. In fact, here it is on the slide. It says preliminary hearing to determine probable cause. A lot of times that same hearing is where you're notified of the charges against you. And there's either an indictment or what we call an information against you. That's the equivalent of a lawsuit from a criminal perspective. Then there's an arraignment, and then there's trial. So those are the steps. A few more steps are involved in the process as compared to a civil dispute, which again makes sense, right? You want it to be that way. You want there to be more checks and balances and controls in place, right? If we're going to take somebody's freedom or life away from them, we want there to be procedural safeguards. We don't want it to be easy. We want the government to be able to jump through all of these hoops, and in particular, right, to provide notice and provide an opportunity for the accused to defend themselves. Very, very important in our legal system. So again, the Fourth Amendment we already talked about. It protects individuals against unreasonable searches and seizures. And most of the case law that we find under the Fourth Amendment are related to drug cases. And there's a couple really, really interesting drug cases that have been decided under the Fourth Amendment, which actually have helped to define privacy rights in the U.S. It's very, very interesting, but if you look at the United States Constitution, we do not have a right to privacy under the United States Constitution. Courts, however, have read privacy rights through the Fourth Amendment, and as a result of all these drug cases that have come out. So again, very, very interesting. Probably, if you guys are interested in that, you could bring it up in class, and I'll be happy to discuss some of those cases with you. Hard to do it here on an online lecture without you need a little bit of back and forth on that one. Fifth Amendment, I already talked about as well, protects persons against self-incrimination, double jeopardy, and being charged with a capital crime, except by a grand jury indictment. Again, just procedural safeguards to protect the accused, to make it that much more difficult for the government to prevail, right? I mean, prevail is not the right word, but we want to make sure that everything is in place. If you're going to be charged with a crime, and again, right, I keep stressing it because I do believe it's very important that if we're going to take your freedom away or we're going to take your life, We want the government to jump through all the hoops. We want everything to be in place. We want to minimize the possibility that an innocent individual ends up in jail or dead. And this is our last slide here. We're actually going to finish up with the Sixth Amendment, again, which provides the accused with the right to a speedy and public trial, the opportunity to confront witnesses, and the right to counsel. That's why when somebody's arrested, right, as part of the Miranda rights, remember, the Miranda rights are not in the Constitution. That came out of a case, I believe it's called Arizona versus Miranda. I can't remember the exact name of the case. I know it as the Miranda case. I believe it's from the 60s. Very, very important case that basically said that an accused, before they can be interrogated, right, before they can be asked all sorts of questions, they have to be read their rights or told what their constitutional rights are, and then they can waive them if they want to, but they don't have to, which to me makes a lot of sense, right? A lot of people, as I mentioned in class, are not familiar with the law. They're not familiar with the Constitution. They have no idea what the rights are. So it's very, very important for the accused to know what their rights are. And obviously, if they want to waive them, they have that right as well, right? But at least they have to know what it is that they're waiving. Now, from my perspective, why you would ever waive any of your rights, I don't know. I think you'd be dumb to waive any of your rights. I don't care if you're innocent. I would never talk to the police. I would never provide a statement. I would exercise my Fifth Amendment right to be silent, and I would ask for my attorney and not talk to them. The danger that you run, even if you haven't done anything wrong, the problem is, remember, these investigators are trained professionals. A lot of times they can play with your mind, they can elicit responses from you, they can twist what you say. You gotta be really, really careful, right? So if you have the right to be silent, why would you ever give that up? Many, many times the police, even if you're guilty, right? Let's assume you're guilty. Many, many times the police have no idea. They have no evidence. A lot of times, most of the evidence that they obtain is because people talk. And they talk too much, right? So the best thing you could always do, whether you're guilty or not, is not to talk, right? So that's what I would do in that situation. Again, right? Remember, you have rights. And why would you ever give up any of the rights that you have? In particular to the government, right? So perfect. This is just an overview then of criminal law, and we will proceed with the next lecture after that. Take care, everybody.